Is there, and I'm assuming there's no law on this to guide the court as to whether or not I can require these things to be done via Zoom. I mean,
Well, they're being done now, even by the public defender's office.
Judge, my office is not doing remote evaluations at this time. David Wheeler on behalf of Mr. Cruz.
where are you, Mr.? Oh, I see you, Mr. Wheeler. Your office is not doing any evaluations via Zoom.
That's correct, Judge.
Just so you know, we were revised by BSO that not Mr. Wheeler personally, but other homicide defense attorneys in the public defender's office were doing it. So that was the basis of our information. That was from BSO.
Mr. Wheeler, is there a chance that you might be mistaken?
Judge, if a homicide does come in, we might have an expert perform an assessment to try to get I guess, an impression at first glance,
Okay.
but it's not an evaluation, ma'am.
Okay, I'm just sort of thinking, that's why I'm waiting. Obviously, this is a new area for everyone, and there's not going to be a whole lot of guidance from the courts on this because, you know, we've only just all been in this situation for a little over, 6 months now. So, so State, you're asking me to order the PD's office to start their interviews via Zoom, and the public defender's office is objecting. Is that the gist of it?
Yes, Your Honor.
I'm taking the state is asking that the jury view, I'm summarizing, the jury view motion and response, as well as the motion to prohibit the state from seeking the death penalty. Once those motions and responses are in, the state is asking that I rule based upon the pleadings. The defense is asking for a hearing on both. Is that correct?
Yes, ma'am.
Okay. So other than that, how are we doing as far as progressing in discovery and getting everything else that needs to be done finished? Hopefully by the end of the year, when the courthouse opens, or the beginning of the year, when the courthouse opens, we can get going.
Judge, we're continuing to take depositions. We have them set through November. Oh, I'm sorry. We also filed, I forgot about this one, a motion for a good faith witness list. I don't know if the court has had a chance to look at the motions to suppress we filed and the responses. That's part of the reason we filed this motion. We've spent hours, Mr. Ehrman, starting with him, and then Ms. McNeil and I doing these motions, only to find out that the state's response on many of them is we're either not calling that witness or we're not even going to try to elicit an identification from that witness. So if we are able to get an actual witness list, or even if it's partially accurate, it would be helpful in terms of saving us time. Every time we take a deposition, Mr. Ehrman or Mr. Wheeler, they spend time preparing for it and preparing to ask questions with the purpose of eventually filing motions to suppress or motions in limine. And then the actual writing of them, we do a lot of research on them. And then, you know, if we were to find out later they're not calling the witness, or they're not going to try to even elicit the testimony we're seeking to preclude, then we've just spent hours and hours for no reason. So if they could provide us with that list, we can look it over, and then we can look at those witnesses and focus depositions on those witnesses, focus our motions on those witnesses. So we're also asking that the court order the state to respond to that in 30 days.
Your Honor, that is ridiculous. The law doesn't call for that. We list the A witnesses and the C witnesses. They've even requested of us to take deposition of the C witnesses. We agreed. They have provided 139 witnesses themselves. We don't know who they're going to call. Our obligation is to provide information as the witnesses who know something about the case. And that's what we have done. As they even point out in their request, there is no law demanding that we do that. And we're being as thorough as we can. And that witness list is appropriate. And there's no law that says that we have to list any other witnesses other than the people that know something about the case. We don't know who they're going to call. They haven't even provided us, who their defense is going to be, if they're going to rely on mental health. We're just sitting and waiting.
Judge, I'm sorry. The state has announced ready for trial many, many times. I mean, we're not suggesting that there's a law that requires them to provide us a good faith witness list. What we're asking for, in order to speed our preparation and prevent us from wasting hours and hours of our time, as we did already, we're just asking that they tell us. We've given them a list of 139 witnesses, as Mr. Satz said. They've given us a list of hundreds and hundreds and hundreds of witnesses. And if what they're saying is they're intending to call every one of them, so be it. Then we need to prepare for every single one of those witnesses and any motion that goes with it. But if they want us to speed our preparation, they can help us in this way.
I mean, why not just do this the old-fashioned way? I mean, maybe I'm on a different planet here, but what happened to just start calling up the other side and saying, hey, I'm getting ready to spend a whole lot of time preparing a motion to suppress on witness A and B. Are you even going to be calling these witnesses? Can you do me the courtesy of letting me know now before I have to file this? And if they say they're not calling them, then ask them to put it in writing. So that, I mean, couldn't that be isn't that an idea that might work?
Judge, it could, and we can try that, although we have tried that before in the context of, excuse me, witnesses who don't want to have to appear or are unable for whatever reason to appear for deposition. And we've said, if it's based on not wanting to subject them to having to deal with this situation, we ask them for a stipulation. And in some instances, they're unable to do that. They won't commit to not calling the witness, so we don't know. If they're willing to do that with respect to any of the witnesses, then we're happy to do that.
Well, at least that would be a step in the direction of shaving off some time. If they're not willing to do it, then I guess you have to go forward, because there's nothing, I agree with Mr. Satz, there's no law that says I have to require them to do that. Even at the time of trial, I can't require them to do that. I can say, call your next witness, but I can't order the state to tell what witnesses they're calling and so on and so forth. So my suggestion would be reach out, try to get some kind of stipulation, let them know that what you're relying on, and so on and so forth, and maybe a stipulation can be done before you have to do all that work. But that's a suggestion. Obviously, it's not an order. I think my hands are tied when it comes to your request as far as the law is concerned. So I'm going to reset this again for a status. I want to look into these few issues that have been brought up. All right, I'm going to set this for November 17th at 8:30 for another status. I'm going to review these motions. I'm going to determine specifically whether the two that have been brought to my attention that I do agree need a hearing or do not need a hearing. I'm going to ask someone from the sheriff's office to be present at the next hearing, maybe their legal counsel, so that they can give us an idea of when these people are going to be allowed to go inside of the jail. And I think that's it for today. Is there anything else on the lead case, the murder case?
No, Judge, just if you're denying our motion for a good faith witness list based on the comments that you've made, can you give us an order on that one?
Yes, as soon as I just want to take a look at the exact motion so that I can name it exactly, my order, exactly what.
Thank you.
I do see, I just saw on my desk, is sitting a stipulation where you all are agreeing that certain witnesses won't be called.
There is one, Judge, yes. And then there was another one where they weren't excuse me, able to enter into a stipulation at this time.
Okay, well, better than nothing. So, and I do have your motion for a good faith witness list, and I will enter an order today, okay?
Thank you.
I'll see you all. Oh, and how about the 1814129? I see Ms. Shooter and Mr. Burke are present. I think I saw both of them.
Yes, good morning, Your Honor. Maria Schneider on behalf of the state.
Good morning, Your Honor. Joseph Burke on behalf of Mr. Cruz.
Hi, how are you? So I'm going to continue this along with the other case to November 17th at 8:30.
That's fine, Judge.
All right, thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Okay, Sheriff?
We have Caitlin Losey, Paul Ryan.
Okay, thank you.
Good morning, Judge Elba Jimenez on her behalf.
How are you?
Good, Judge.
Ms. Losi, a motion for release, and she appears on page 12 of the docket. Who's the state for this? Who's the state in this?
Good morning, Judge. Toby Forpesson on behalf of the state.
Okay,
Yes, Judge, I filed the bond motion on her behalf. Judge, she only has this case pending. She was previously in drug court. However, it was transferred out of drug court back to your division based on a capias. There was a miscommunication with her court date back in January 2020, which is the reason why she missed court. And that's the only reason why she's being held no bond currently in custody, Judge. She does have a place to live with her fiance, her 5-year-old son, and her father-in-law. She does have the address, and Judge will be asking if Your Honor would release her on standard pretrial. I have explained to her that there will be future court dates that she does need to attend to, and I do have multiple phone numbers for her, and she does understand that she will be in communication with myself. So we'll be asking for standard pretrial.
state,
Judge, due to the fact that the defendant essentially absconded for 7 months, I mean, I understand there was a miscommunication, but still 7 months that went by. This is her first felony. I would agree to level 2 pretrial with a GPS. I would also ask for, on counts 1, 2, and 3, the felony counts, I'd ask for $1,000 bond and an ROR on count 4, just to ensure future appearances in court.
does she have any prior state?
Judge, it looks like just a 2 misdemeanors from 2015 to 2016, a no valid DL and a DWS. That's it.
All right, I'm going to set bond in the amount of $1,000 on counts 1 through 3, ROR on count 4. The defendant is going to be supervised by pretrial services, level 2 with a monitor. The defendant is not to consume any alcohol or intoxicants, and she's to be tested at a minimum of 2 times per month at her own expense, and that is to be random testing. And I'm going to set the case. Have the charges been filed, Ms. Jimenez?
Yes, Judge, they have been filed.
Has she been arraigned, do you know?
Judge, I don't believe she's been arraigned. That's when the capias was issued.
That's
Okay.
correct.
I'm going to go ahead and arraign her now and set the case for a tentative calendar call.